If you think you're safe because the federal agencies that regulate your financial markets, your workplace protections, your communications networks, and your consumer financial rights are protected from direct presidential control, what the Supreme Court did on June 29, 2026, just changed that. In a 6-3 decision in Trump versus Slaughter, every justice in the conservative majority agreed. The President of the United States can fire the leaders of approximately 24 federal agencies that Congress specifically designed to operate independently of White House control. The FTC, the NLRB, the FCC, the CFPB, the SEC, the FERC, the EEOC, all of them. The constitutional guardrail that kept these agencies independent has been in place for 91 years. The Supreme Court just eliminated it. Subscribe right now because this decision was issued hours ago, and its consequences will be felt across every corner of the American economy and government for years. Let me start with who Rebecca Slaughter is and what happened to her, because her story is the vehicle through which the Supreme Court just changed American constitutional law permanently. Rebecca Slaughter is a Democratic FTC commissioner. The FTC, the Federal Trade Commission, is a federal agency that enforces antitrust law and protects consumers from unfair or deceptive business practices. It has 5 commissioners, no more than 3 of whom may come from any one political party. Each commissioner is appointed by the President and confirmed by the Senate. Originally, Slaughter was actually nominated to fill a Democratic seat by President Trump during his first term. She was later renominated by President Biden in 2023 to serve a second term expiring in 2029. Trump fired her before that term expired. Slaughter sued, arguing that under the FTC Act, commissioners can only be removed for inefficiency, neglect of duty, or malfeasance in office. Trump's firing, she argued, violated that for-cause protection. Therefore, she was still lawfully the FTC commissioner and could not be removed. The lower court sided with Slaughter. The case went to the Supreme Court, and today the Supreme Court reversed. Chief Justice John Roberts wrote a 36-page majority opinion joined by Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett. The 6 conservative justices agreed. Slaughter can be fired. The for-cause removal protection is unconstitutional, and in reaching that conclusion, they explicitly overruled one of the most important precedents in American administrative law. The case is Humphrey's Executor versus United States, decided in 1935. To understand why today's ruling is a true legal earthquake, you need to understand what Humphrey's Executor was and why it has governed American government for nearly a century. In 1935, President Franklin Roosevelt fired William Humphrey from his position as an FTC commissioner, claiming the right to do so because Humphrey's political views were not aligned with the New Deal agenda. Humphrey's estate sued, arguing that under the FTC Act's for-cause removal protection, Roosevelt did not have the right to fire Humphrey except for cause. The Supreme Court agreed with Humphrey's estate. In an 8-0 decision, the court held that Congress can create agencies to perform quasi-legislative and quasi-judicial functions and can protect those agencies' leadership from at-will presidential removal. This was the constitutional justification for the entire modern administrative state. The New Deal agencies, the post-war regulatory bodies, and every independent agency created in the decades since, all of them were built on the foundation that Humphrey's Executor provided. Congress could design agencies that were genuinely insulated from direct White House control. The president could not simply fire agency heads because he disagreed with their policy decisions. For 91 years, that foundation held. Democratic and Republican presidents, liberal and conservative courts, all recognized Humphrey's Executor as binding precedent. The modern regulatory state was built around it. Consumer protection agencies, securities regulators, labor boards, communications oversight, all of these exist in their current form because of the constitutional space that Humphrey's Executor carved out. That space is now gone. If you are finding this important, subscribe right now. Because what just happened today affects not just who runs which agency, but the fundamental structure of the American government. And the practical consequences for ordinary Americans are enormous. Here is what Chief Justice Roberts' majority opinion actually says. Roberts begins with the constitutional text. Article 2 of the Constitution vests the executive power in a President of the United States. That executive power, Roberts argues, has historically been understood to include the power to appoint and remove executive officers. The founders created a unitary executive specifically so that there would be one person accountable to the public for the actions of the executive branch. That accountability requires control, and control requires the ability to remove subordinates who are not carrying out the president's wishes. Roberts acknowledges Humphrey's executor but says it was wrongly decided. He argues that the functions the FTC and similar agencies perform are executive functions, not quasi-legislative or quasi-judicial functions, as the 1935 court had characterized them. Congress cannot take executive functions, hand them to commissioners, and then insulate those commissioners from presidential removal. That arrangement violates the separation of powers because it places executive power in the hands of people the president cannot control. Roberts then extends this reasoning beyond just the FTC to all multi-member independent agencies with similar for-cause removal protections. The decision does not just affect the FTC. It affects every agency where Congress has tried to protect commissioners or board members from at-will presidential removal. The companion case, Trump versus Cook, specifically addresses Federal Reserve Governor Lisa Cook, and the court's ruling applies to her situation as well. The scope of what just happened today covers approximately 24 independent agencies. That number represents an enormous swath of the federal government. Hey, 73% of people watching right now are not subscribed. What was decided today is one of the most consequential Supreme Court rulings in decades on the structure of the federal government. Subscribe right now so you never miss the follow-on developments as this ruling reshapes agency after agency. Let me tell you about Justice Sotomayor's dissent because it is worth reading in full and understanding. Sotomayor wrote 49 pages. She was joined by Justices Kagan and Jackson. The dissent begins with a stark statement of what she believes the majority has done. Today, she writes, the court discards the democratic regime created by the Constitution in favor of one that distorts the structure of government to fit the majority's theory of unitary, total executive control. The result, she concludes, is a president who emerges with far greater power than ever before. Sotomayor argues that the majority's unitary executive theory is not supported by the historical record. The founders were suspicious of concentrated executive power. The separation of powers was designed to prevent any single branch from accumulating too much authority. Allowing Congress to create agencies with some insulation from presidential control was a structural choice that reflected the complexity of the modern state, not a violation of the Constitution. Sotomayor also argues that the majority is simply wrong about what Humphrey's executor held and why. She argues the 1935 court correctly understood that agencies performing complex regulatory functions needed some protection from the political winds of presidential administrations to function effectively and fairly. An FTC commissioner, who can be fired for any reason by a president whose political donors are being investigated by the FTC, is not really independent. And an FTC that is not independent is an FTC that serves the political interests of whoever happens to be in the White House. Sotomayor catalogs the ways independent agencies have played essential roles in American life. The NLRB enforcing workers' rights to organize, the SEC enforcing securities laws that protect investors, the CFPB protecting consumers from predatory lending, the EEOC enforcing civil rights laws in the workplace. All of these agencies, in Sotomayor's view, have functioned as they did in part because of the structural protection that Humphrey's executor provided. That protection is now gone. Let me now give you the specific practical implications of today's ruling. And I want to be concrete because this is where the real-world stakes become visible. First, the president can now fire any commissioner, board member, or director of any independent agency for any reason. You disagree with my policy? Fired. You opened an investigation into one of my allies? Fired. You refused to drop an enforcement action? Fired. You publicly criticized my administration? Fired. None of those reasons require the president to prove inefficiency, neglect, or malfeasance. The for-cause protection is gone. Second, the agencies that are affected span virtually every major regulatory domain. The Federal Trade Commission regulates antitrust and consumer protection. The National Labor Relations Board oversees collective bargaining and workers' rights. The Federal Communications Commission regulates radio, television, and telecommunications. The Consumer Financial Protection Bureau protects consumers in financial transactions including mortgages, credit cards, and payday loans. The Securities and Exchange Commission regulates securities markets and investment firms. The Federal Energy Regulatory Commission regulates interstate electric transmission and wholesale electricity markets. The Equal Employment Opportunity Commission enforces federal laws against employment discrimination. All of these agencies, and approximately 18 others, are now subject to at-will presidential removal of their leadership. Third, the stability of these agencies' enforcement actions and rulemaking is now in question. Investigations that have been ongoing for years can be shut down by firing the commissioners overseeing them and replacing them with people who will drop the cases. Rules that took years to develop through formal rulemaking procedures can be abandoned by new leadership installed after a political firing. The continuity that made independent agencies function across presidential administrations is now vulnerable. Fourth, the ruling affects not just the current president, but all future presidents. Today's ruling grants this power not just to Trump, but to every president who follows. A future Democratic president has the same new authority to fire Republican-appointed commissioners before their terms expire. Whatever you think of the political valence today, the structural change is permanent until the Supreme Court reverses itself, which given today's ruling appears unlikely. Let me also put this ruling in context of the broader constitutional developments of the 2025 to 2026 Supreme Court term. This court term has been one of the most active in recent memory on questions of executive power. The tariff cases resulted in a ruling earlier this term that limited some aspects of the president's tariff authority. The birthright citizenship case, Trump versus Barbara, is expected to be decided within days. The question in that case is whether Trump can end birthright citizenship through executive order, which was argued on April 1st and on which a ruling is imminent. And now today's ruling dramatically expands presidential control over the administrative state. The conservative majority's theory of unitary executive power has been building for decades, and today's ruling represents its most dramatic assertion yet. Now let me address the question of what happens next. The ruling is binding immediately. Rebecca Slaughter's lawsuit is over. She was fired by Trump, and today's ruling means that firing was constitutional. The agencies that have for-cause removal protections are now operating with the knowledge that their commissioners and board members serve at the president's pleasure. Expect the White House to move quickly to leverage this new authority in agencies that the administration has found resistant to its policy priorities. At the CFPB, which Trump has already sought to significantly curtail through other means, the new removal power creates yet another avenue for political control. At the NLRB, which has been pursuing cases adverse to several major Trump allies and businesses, the new removal authority creates leverage to change direction. At the FCC, ongoing regulatory matters around broadcast licensing and digital communications will now be subject to commissioners who serve at will rather than for fixed terms. Congress could theoretically respond by passing new laws restructuring agencies in ways that comply with today's ruling while preserving some institutional independence. For example, Congress could restructure agencies so their functions are purely adjudicative, which the court has suggested might support more protection from removal. But passing legislation in the current political environment to constrain presidential power would face significant obstacles. And even if passed, the constitutionality of any such structure would now need to be reevaluated in light of today's ruling. Here is what you need to take away from today's decision. The Supreme Court, in a 6-3 ruling decided today, June 29, 2026, gave the President of the United States the power to fire leaders of approximately 24 federal agencies that Congress designed to be independent of White House control. This overrules 91 years of precedent established in Humphrey's executor. It reflects the unitary executive theory that has been building in conservative legal circles for decades. It has immediate practical consequences for antitrust enforcement, labor relations, consumer protection, securities regulation, communications policy, energy regulation, and employment discrimination law. Justice Sotomayor called it a result where the president emerges with far greater power than ever before. Chief Justice Roberts calls it a constitutionally necessary restoration of executive accountability. Wherever you stand politically, this is a structural change to the American government that will outlast this president and affect every president who follows. It is a genuine legal earthquake, not because of any single agency or any single commissioner, but because the constitutional framework that has governed the relationship between the president and the federal regulatory state for 91 years has been fundamentally rewritten in a 36-page opinion delivered this morning. Subscribe right now because the birthright citizenship ruling in Trump versus Barbara is expected within days, and that decision will be the final major ruling of this extraordinary Supreme Court term. When it lands, I will have complete coverage and analysis immediately. This channel exists to give you the accurate story behind the headlines. Today's ruling in Trump versus Slaughter is one of the most important constitutional decisions in a generation. Make sure you understand it correctly. And please remember, this is educational content only, not legal advice. For questions about how this ruling specifically affects your workplace, your investments, or any regulatory matter that affects you, consult a qualified attorney.